Good afternoon, everyone. I hope you're all well and keeping safe. Welcome to the LAW2020 online Wills and Probate Shape the Debate with me, Alex Avery from Estate Research. I'll be hosting today's event. And in this live session, you can put your questions to Professor Leslie King and John Thurston and interact as the information is being delivered. Now, today's live Q&A is due to last 1 hour. And we'll cover your pre-submitted and live questions. To the right-hand side, you should see a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. So just to give you some introductions, for those of you who don't know myself, my name is Alex Avery. I've been a professional genealogist for over 25 years. And I've worked and assisted clients in the UK and overseas, including solicitors, banks, and public trustees, to locate missing heirs across the world. I speak on the TSG Wills and Probate conferences, advising the solicitors of the risks of unknown heirs on estate administration. Estate Research are a firm of international probate genealogists established in 2001 and offer various fee solutions for tracing and locating missing heirs, legatees, executors and beneficiaries across the globe. We have an excellent track record in tracing missing heirs and can solve even the most problematic cases. Please refer to our website for further details, which is www.estateresearch.co.uk. Now, my two guests are Professor Leslie King. Professor Leslie King is a former member of the Probate and Estates Committee of STEP, a former member of the Law Society's Wills and Equity Committee, and an honorary member of the Association of Contentious Trust and Probate Specialists. She is a professional development consultant at the University of Law and a consultant for Beckbury Advisory Services. She is the Wills and Probate columnist for the Law Society Gazette and the author of a number of books. She writes and lectures extensively on wills, taxation and related matters. As part of the LAW2020 online Wills and Probate, Professor Leslie's sessions included Introduction to Charities and Preparing Wills for Elderly Clients. My next guest is John Thurston. John Thurston, LLB TEP, is a non-practicing solicitor. He is particularly interested in the law relating to wills, trust, taxation, powers of attorney and elderly clients. He is the author of various books and contributes to loose leaf works. He has practiced and is now a trainer, and John's sessions for LAW2020 online Wills and Probate included Post-Death Problems and Pitfalls sessions 1 and 2. So to kick off, we'll start addressing some of the pre-submitted questions we have been receiving from you. And first of all, I'll put this to you, Leslie. First question here is it true that the Ministry of Justice has published an attestation clause for use in video witnessed wills?
Well, they've published something which they say is not prescriptive and it's intended to be guidance. You can see it if you've got access to the Law Society's practice notes. I have to choose my words wisely here. I'm not a great fan of it, to say the least, but have a look at it. To my mind, it isn't actually an attestation clause as such, because with an attestation clause, you normally simply recite that the requirements of Section 9 of the Wills Act have been complied with. So you'd say that the will was signed by the testator in the joint presence of the two witnesses who afterwards signed. This one has all sorts of extra bits and pieces. So that the witnesses are saying that the testator appeared to be of sound mind and appeared to be acting without undue influence. And your witnesses might be able to say that, but it depends how much interaction they've had with the testator. So if I was doing a will to be remotely witnessed for a client, I would amend my attestation clause to recite that the will was signed by the testator in the virtual presence of witnesses, who afterwards signed via a remote link. So I would do that. And then I would probably have a separate document where the person who had prepared the will, spoken to the testator, and ideally overseen the execution, that person who knew the testator could then make those statements about capacity and lack of apparent undue influence. But myself, I wouldn't include them in the will. I don't know what you think, John.
No, well, I tend to agree with you on that. Yes, certainly. I think there's a video witnessing a will seems to me could cause an awful lot of problems, couldn't it, actually, at the end of the day?
Oh, well, I mean, the big risk is that your will isn't valid until both the testator and the two witnesses have finished the signing.
Yeah.
So if you're trying to get the will from the testator to the witnesses, you've got that risk that the testator is going to die in that interim period.
And will they be able to comply with all these rules, in effect? It's another issue as well, isn't it?
Well, it's quite difficult because, of course, the witnesses have to see the act of signing.
Yes,
Well, if you look at how we're all sitting now, we can all see each other's head and shoulders.
Yes.
But unless I do something, you know, you can't actually see me signing. And even if I do that, I don't think you would be able to see my document. So actually setting the thing up so that the witnesses can see the testator actually signing will be quite difficult, I think.
Yeah.
Last resort is what they say.
Yes, I agree.
Thank you, Leslie. The second question here is for you, John. We have sold the deceased house for more than the market value at the date of death. The estate is not liable to IHT. Is the increase in value subject to capital gains tax?
Yes, I think this is going to be quite a big issue, actually, because I think you're probably well aware, if you sell residential property and you make a gain, you have to pay the capital gains tax within 30 days, actually. Now, this wasn't the question, but I mean, if there is an inheritance tax payable on the estate of a deceased person, the revenue agree the value of the deceased house for inheritance tax purposes, that actually becomes the base cost of the executors and administrators as far as capital gains tax is concerned. So if they go and sell it for more than has been agreed with the revenue for IHT purposes, yeah, they're going to have to pay this capital gains tax or the increase in value, again, within this 30 days. But the question really is where there's no inheritance tax payable. Perhaps you've done an IHT 205, and then the executors, administrators go and sell the house for considerably more than they've put in the IHT 205. And I suppose they might like to substitute the sale price for what they've put in the IHT 205, because it's quite possible there's still no inheritance tax payable on the estate of the deceased person, actually. But, I mean, the answer really is, if the house really has gone up from the date of death, then there is this liability for capital gains tax on the executors and administrators. And I think there's a bit of a tendency with the states where there's no inheritance tax payable for the relatives, executors, and administrators to go to estate agents and get some value off the estate agent, in effect, actually. And whilst I don't want to be rude about estate agents, I'd much rather go to a chartered surveyor, actually. So I think if I was faced with that, I think there's two ways of dealing with it. And of course, time is very much of the essence, isn't it? Well, you've got to pay the capital gains tax within 30 days. I think I would say if you haven't gone to a chartered surveyor, go to a chartered surveyor and ask for market valuation as at the date of death. And then if, well, a chartered surveyor comes back and says that, well, it really was the sale price, maybe you'd have to pay capital gains tax. But if the chartered surveyor comes back and says what was put in the IH 205 was the correct figure, then yeah, you've got to pay capital gains tax on it. And also there is a procedure where inheritance tax is payable in effect for getting the revenue to agree what the market value was at the date of death. But I've never actually used that procedure. And I would imagine it probably takes quite a bit of time before they will respond to it, actually. And of course, given that you've got to pay this capital gains tax within 30 days or have penalties imposed on you, I think, yes, it could be quite difficult. But I think if someone wants to be really certain then I suppose the advice is, before you actually exchange contracts, go through this procedure to try and get the revenue to agree what was the market value at the day of death. And I suspect that might delay the sale. But if they don't want to wait, then I think they've relied upon estate agents. Perhaps they ought to get a charter surveyor's valuation and rely upon that and hope for the best.
Can I just chip in with something?
Yes.
It's a CG34, and like John,
Yes,
I've never
right.
actually had to do it, but it's called a post-transaction check.
Yeah.
And I don't think that certainly up till now, you haven't been able to do it until you've actually disposed of the asset.
Right.
And therefore, it wouldn't be any help at all, I don't think, where you've got to pay your capital gains tax within 30 days. That's the view I've been taking rather tentatively, although it may be that the revenue alters its practice. But I totally agree. If you haven't paid IHT on the estate and you know you're going to be selling a house, I would always go for the RICS valuation as at the date of death. And then it's their job to argue with the revenue if the revenue disagrees, which I always think is a great help.
Yes, that's right. Agree. It gets the executives, administrators, and I think us off the hook, doesn't it?
Yeah, absolutely.
These person actually, and you can waive a charter surveyor's valuation under the noses of the revenue in effect. Actually, say we relied upon that.
Yeah.
Thank you, John. There's a question here which might be for myself to have a look at.
Oh, good.
We are dealing with an intestate estate, and my client believes they may know where all the heirs are. However, they're not completely sure. Would you suggest independently verifying the family tree prior to any distribution? And are there insurance policies available if some heirs cannot be located? Well, I would say in my experience that it is worth checking a family tree that you're provided by your client. I think particularly when you're dealing with an intestacy and you're dealing with an estate where you may have cousins involved, usually what will happen there, I find, is that one side of the family may be fairly well known. It's usually the mum's side, but usually the father's side is usually the side that maybe isn't known very well, just seems to be sort of statistically the way it is. And it's definitely worth having that verified before you distribute, particularly if either your client's trying to distribute it themselves, which we've come across, or if your firm's acting as the attorney on behalf of the administrator. I mean, I've had a case recently where the family have done a lot of the research themselves, and it's not too bad. It's fairly accurate, but actually there are parts of the family which are completely incorrect. So that's why I'd always recommend, I don't know how John and Leslie feel, verifying an estate prior to distribution, just in case. I mean, some intestacies are fairly straightforward. You have a surviving spouse, you have 2 children, etc., and you know who the beneficiaries are. But I think if you have a deceased who's been married multiple times or has multiple siblings from a large family, or when you have cousins involved, I do think there's far more risk there. It's definitely worth checking it out.
I feel quite faint at the idea of distributing without checking when you've got that sort of complicated family, because you can just guarantee that there'll be problems. And, it's the PRs who are liable. And if they haven't been warned by their professional advisors, then the professional advisors are on the hook too.
Yeah, that's right. I agree. So quite often it is relatively straightforward, but someone who's apparently never had any children, never been married or anything like that, or a civil partnership, can be very difficult, can't it, actually?
Yeah.
My wife has been investigating her ancestors and my ancestors, but I have a huge number of relatives I didn't know about, I think.
There you go.
Best to keep it that way often.
Partly because I thought my grandmother just had the one brother. When they were around, that was my father's uncle, there never was any suggestion of any more uncles and aunts. But apparently this grandmother of mine was one of 9 children.
Yeah. It's funny how often we hear it in a profession. The deceased father is an only child and he's one of 10 or 11. And there are insurance policies, obviously, you can get if you have missing beneficiaries, or even if you think you've got all the beneficiaries, you can get insurance to cover yourselves as administrator. Thank you. So
I'm
the
on
next
the
question is next question is for you, Leslie. What do you do if your client refuses to have a capacity report?
I think it depends why you were suggesting the capacity report in the first place. It's the client's choice whether or not to undergo an assessment of their testamentary capacity. And they may say no for a whole raft of reasons, one being that they just don't want to receive any bad news. I can't say I would particularly relish the idea of undergoing an assessment of my mental capacity. So the client may well say no. They may not want to pay for it. They may think that it's entirely unnecessary. I would always point out to the client the reasons why it might be a good idea to think about getting an assessment of mental capacity, even if you are quite happy insofar as you can tell that the client has got capacity. If it's what I call a potentially divisive will, where, you know, some close member of the family is being cut out, you can be pretty sure that there's going to be a challenge. And it's worth saying to the client, well, getting a capacity report won't prevent a challenge. It will make it slightly less likely. And also it will make it less likely that the challenge is going to succeed. There are also possible costs issues if a will is challenged and there wasn't a contemporaneous medical report. That may be a reason why a court might decide not to make a costs order. So I'd point all those things out to the client, but they say, no, I don't care. I'm not spending the money. I don't want to do this. I think you then have to consider whether you are happy doing the will for this person. And the most helpful case that I know of is a case called Sharp and Adam. And in Sharp and Adam, I've forgotten who it was now, but anyway, the judge hearing the case talked about what you should do if you're making a will for somebody and you're not sure whether or not they have capacity. You think it's probably more likely than not that they do, but you're not sure. And what the judge said was, well, point out to the client the reasons why they should consider a report. Point out to them that the will might be challenged after their death if they don't have a report. If the client wants to go ahead, then you should go ahead and make the will, because if you refuse, you're denying the client the chance to have their testamentary wishes put into effect. I always add at the end of that that's fine for a judge. And they're not the ones who are going to have to produce the witness statement, be potentially cross-examined on what they did and why they formed the view that they formed about the testator's capacity. And if you're meeting the client for the first time and you are genuinely in two minds about whether or not they have capacity, my slightly self-serving advice would be to say, well, actually, if you're not willing to have a report, I don't think I can act for you. But if you think it's more likely than not that they do, then go ahead and make the will, but do a very full attendance note, setting out your reasons for coming to the conclusion that they probably did fulfill the elements of the Banks and Goodfellow test. And I would be quite thorough. I would go through in my attendance note each element of the Banks and Goodfellow test. So did they appear to understand the nature of a will? Did they appear to understand the extent of their property? Did they appear to understand the people that they ought to be thinking about? Was there any evidence of any disorder of the mind? And I would address all those things. And I'd also try and put into the attendance note the testator's actual words and what they said, because that's very strong evidence. Some firms have standard sort of questionnaires or checklists which have those sort of questions on one side, and then you can tick, yes, they did appear to understand the nature of a will. And there's normally a space where you can put in, you know, quotes from what the client said, and that's quite helpful. There's one other thing I was going to say. which has now gone from my mind completely. But if you want to add anything, John, I might come up with the thing that I've just forgotten.
Right. Yes. I think certainly the area I come from, the GPs seem very reluctant to give reports about whether someone's got capacity or not. Well, the last time I tried to get it, the GP said, "Oh, no, I don't do that type of thing." Referred me to a consultant geriatric psychiatrist. And
Yeah.
I rang the consultant geriatric psychiatrist up, and I can't remember how much he wanted, but it was probably about £500 in total at the end of the day, actually. So I had to go back to the client and say, "Well, will you pay?" And of course, the answer is no.
Yeah, that's one of the reasons why clients will very often say, "No, I don't want to report. I'm not going to pay that much."
And I did the will for this client because the reason why I wanted the report was she was cutting out her closest relative, her niece. Well, not cutting her out completely, but certainly instead of getting the whole of the residuary estate, she was just getting one half. But I thought, well, fair enough. I mean, I'm quite certain this lady's got capacity, so you have to make a full attendance out, don't you? As to what your
absolutely
got capacity.
I've just remembered my missing point.
All right.
My missing point is, particularly if you're taking instructions remotely, you might want to think about recording. I mean, obviously, there are problems with storing recordings and technology going out of date, but it is quite helpful if you have got a recording, and courts will certainly look at them. I can think of 2 cases where courts looked at a recording, not actually of taking instructions. One was a recording of a family birthday party at which the deceased was present, and the other one was an audio recording of execution. But the court certainly found in both cases that the recording was quite helpful.
Yeah. And I think also if someone wants to cut out relatives, and Sharp and Adam, the case you mentioned, he was cutting out his daughters, wasn't he? Actually,
he was.
Yeah. Well, I know. I think poor man had multiple sclerosis and lost the ability to speak. But
He did.
I think it's quite a good idea, perhaps, if they do want to cut out relatives and they are still on sort of speaking terms, to tell them to go and speak to the relative they want to cut out and see if they agree.
Yeah, they'll usually say no.
Yeah, they'll probably say no, but there we are. It might eliminate a dispute later on, certainly. I mean, the other issue as well, actually, is someone who's terminally ill. And, you're told they haven't got very long to live, with terminal cancer or something like that. Well, I mean, I think the mere fact someone's got terminal cancer doesn't mean that they've lost capacity or anything like that. But again, I mean, that can be a difficult one.
Well, the thing that you don't want to do is to say to the client, "We'd better get you a medical report." The client says, "No, right, if I've got to." And then, for example, you contact the GP. In one case that I've been lecturing quite extensively for the last few months, because I thought the firm involved did such a good job, but they did say to the client, "Get a medical report," because she was cutting out one of her daughters. So immediately you're, anxious.
Yes.
She agreed to get the medical report. They wrote to the GP in November, and they got the medical report in May. And in that period, they were quite lucky because the woman, the testator, went into hospital having had a bad fall. So if she died in that period, they hadn't made the will. So certainly when there's any kind of, time constraint or serious illness, you don't really want to be delaying, which is one reason why, if the client is willing to pay, a specialist capacity provider rather than a GP is a good idea, because they will give you a realistic time frame in which they will produce the report. Whereas inevitably, it's not top of any GP's list, is it, of priorities? It's going to be down the bottom if they're willing to do it at all.
Yeah, I mean, sometimes it might be that you're told the person's only got a week or so to live, so there's no way you're going to get a medical report in a week. And I think my attitude is you've got to make your own assessment and do the will, because I'd rather the client died with the will they want than the one they don't want, actually.
Absolutely.
Yes.
And just on that, I was listening to a podcast from the chair of the Wills and Equity Committee, who does a lot of deathbed wills. And he said he always tries, at the very least, to take a photograph of the person with their consent, obviously, because he says again, it's quite powerful whether the person is kind of, slumped over, barely conscious, or whether they're actually sitting up in bed quite chipper. It makes a difference if you're cutting somebody out.
Yes. Right.
Thank you. There's a question here for you, John, which we've actually had in. They've asked me to ask. So the value of the deceased estate is approximately £402,000. 95% of the estate, which consists of only one property, is to go to the spouse of the deceased. Will the spouse exemption apply?
Oh, yes. As long as they're domiciled in the United Kingdom, no problem. Yeah.
Okay, that's great. Okay, excellent. Thank you.
No doubt about that. If they're not domiciled in the United Kingdom, there might be a bit of an issue, but there we are.
And here's another question, although this is for you, John. Leslie, you probably like to sort of answer it as well. Should the cost of finding a missing beneficiary come out of the residuary estate and be borne by all the beneficiaries, or should it come out of what the missing beneficiary is entitled to?
Yeah, because it's very relevant to you, isn't it?
Well, actually, it is actually. Yeah, I've got my own sort of idea.
We'll all answer this one.
I think we'll all answer it. Yeah.
Beneficiary. As far as I'm aware, there's not a huge amount of case law about this, or certainly recent case law actually about this at all. Actually, but I think the only case I know about is a case called Ree Evans, where a man died intestate, no spouse, son and daughter, the son and daughter not had anything to do with each other for, I think, in excess of 30 odd years or so. But daughter goes to see solicitors and says, father's died intestate, no spouse, got this brother, not heard from him for 30 odd years or so, and no idea whether he's dead or alive, and tells the solicitor to sort out this man's estate. And all they do to find this man is put an advert in the News of the World, which, of course, is now bitten the dust. But I have been told, it's not a newspaper I used to take or anything like that, but it used to have a page of missing beneficiaries, actually. I don't know whether the Sun on Sunday has a similar page. But, of course, the brother didn't see it, so took out a missing beneficiary indemnity policy with the Sun Alliance, and then handed out the net residuary estate to the daughter. And, of course, brother's very much around, finds out father's gone and died, comes and claims 1/2 of the net residuary estate from the Sun Alliance. And they have litigation about what are proper administration expenses. And the judge rather glosses over whether they should have done a bit more about finding this missing brother, actually. But says, okay, well, if you can't find a beneficiary, cheapest way is to get one of these missing beneficiary indemnity policies, rather than to go along to the Chancery Division and ask, I think, for what's known as a Benjamin order, leave to distribute the assets on the basis the beneficiary is dead. So apart from sort of glossing over whether these solicitors should have done a bit more about finding this brother, quite happy with what they'd done. And he did hold that the missing beneficiary indemnity policy premium was a proper expense of the estate, that the solicitor's charges for sorting out the estate were a proper expense as well. But I think the bill the solicitors had incurred when the brother came forward and claimed his half, that wasn't held to be a proper administration expense. And I suspect they never got paid for that, because they don't have any contract with the brother, and their contract with the son and their contract with the daughter would have terminated when they handed out the net residuary estate to her. The daughter also sought to charge £500 for work she'd done, I think it was, in connection with the estate, actually. But I think there's two arguments here. One is, of course, personal representatives are under a duty to find all the beneficiaries. So from that point of view, you could argue that the cost of finding the missing beneficiaries should come out of what they're entitled to. Sorry, I was trying to come out of the residuary estate, rather, because it is one of the duties, as I say, of personal representatives to find all the beneficiaries. But I suppose you could argue that if it's the fault of the beneficiary they've gone missing, then the cost of finding them should come out of what the missing beneficiary is entitled to. But I think my experience of families do drift apart, don't they, actually? And there's really fault on both sides, actually. It's very difficult to say that it is the fault of the missing beneficiary that they've gone missing, in effect, actually. So I think for my money, yes, the cost of finding a missing beneficiary should come out of the residuary estate and be borne by all the residuary beneficiaries, actually. But
I would, roughly speaking, agree with that. And there are some 19th century cases the rules of the Supreme Court used to say something about this, but no longer do. But insofar as there is authority, the authority suggests that the cost falls on the estate because, exactly as John says, it's the PR's job. I saw a very interesting article written by, I'm not going to be able to remember who, but quite a well-known barrister in private client areas. And I think it was a she. And she suggested that it's not clear, but that possibly the cost of identifying how many shares the residue has to be divided into, that's perhaps your proper residuary expense. And possibly when you have decided with the aid of a genealogist how many shares there are, actually finding the individuals might conceivably be justified to come out of their share. But this was very much, what seems fair. But I think insofar as there is a legal argument, it's that the cost should come out of the estate.
Yes, no, there are small 19th century cases which suggest it's a proper administration expense and should be borne by all the residuary beneficiaries. But I mean, I would also say that if you spend some money trying to find a beneficiary, that you can't find them, there must come a point where you have to say, well, that's it. We can't expect the residuary beneficiaries to bear any more costs. And if we incur any additional costs, then it's got to come out of what the beneficiary is entitled to.
Isn't the answer you use somebody like Alex to
that's right.
do whatever you can when you reach your dead end and you think you've spent enough, see if you can get an insurance policy.
Yes. Yeah, I mean, the insurer nowadays will want quite an extensive amount of work being done before they issue a policy. And we've had some very difficult cases over the years, as in trying to find someone. And the trouble that you have is if someone is genuinely missing and hasn't been seen for decades, you don't quite know where they've gone. I mean, which countries you started in, and then how do you possibly come up with a charge to the estate? Because you're sort of saying, I'd have no idea where this person's, we could try America, we could try New Zealand, we could try Australia, and the cost could rack up quite a lot. Whereas if you sort of go on the line of, well, look, if we find this person, they will pay the fee from their share. It allows a lot more flexibility from our point of view of trying to find this person, and reaching worldwide, and the cost is kind of borne by us in some ways to find the person. That's the job you're hiring us for. You want the person found, and that's our job. And usually, that nowadays, as records have become more available in different jurisdictions, 20 years ago when I started this, it would have been very difficult to find a lot of people who'd gone overseas. But now it is slightly easier. We can get access to records, and we can get in contact with people in different jurisdictions. I mean, we found someone in Chad, last year, and he'd been missing for 50 years. And lo and behold, he was working out there. And it took a long time, but we got there in the end. And that one was one where we asked for a fee from the beneficiary's share rather than from the estate, because we just didn't know if we were ever going to find him. But I can sort of see the argument either way. So thank you very much. We've just had a question come in that related to the previous question about the capacity issue. And someone has asked, what about asking the client for a higher fee to take account of the extra work required in regards to reduced capacity clients?
You are required, I've forgotten the name of the regulations, but you are required to publish sort of your basic charges. So if you're going to say to somebody that we will be charging more if we have to deal with issues of capacity, you would have to, I think, have published that and warned them in advance. I suppose if you say to them, well, look, you can have a medical report for which you will have to pay, or I can write a very detailed report and you will have to pay for my time. I suppose if they agree to that, that's justifiable. On the other hand, there is a bit of me that thinks, well, if you're acting for a client, It is your job to make an attendance note. It is your job to deal with the various things that are relevant. So I'm not sure that I would be feeling terribly comfortable about a much increased charge because I was having to address the question of the client's capacity, unless it was a very difficult scenario like the Sharp and Adam one, where, as John said, this poor chap was suffering from very advanced multiple sclerosis and couldn't actually speak. And the solicitor who was involved wrote, I would say, a minor novel in terms of her attendance note, explaining how she had communicated with him, which was extremely creative because she had to have sort of, photographs, pieces of paper representing assets, representing beneficiaries. And you can see there, that is a tailor-made Rolls-Royce performance for which you would be making a separate charge. But you have just got to be a little bit cautious about what have I advertised as my charges and what carve-outs have I allowed for. Do you think, John?
Yes, I agree with you, actually. Yes. And I think a lot of clients are probably going to object if you try and add a bit on. So you've got to put
unless you warn them in advance.
Yes, unless you've told him in advance. Yes, I agree. Yeah.
Thank you. There's another question come in here. With the CGT reporting requirements within 30 days, if the PR is non-resident or one of the PRs is non-resident, do you still need to report the sale even if there is no capital gains tax payable?
No, I think it's the answer to that, actually, isn't it? Yeah, I think I need to look at exactly the regulations again, but I think the answer is really no, that they don't really want to know if there's no capital gains tax payable.
I think that the estate takes, and I'm just trying to remember, doesn't the estate take the residence position of the PRs? And if it's equal, then the residence of the deceased is a tiebreaker. Because I think what this question's getting at is for non-UK residents, they have to report a sale of a UK property irrespective of their tax to pay. It's only if you're a UK resident disposing of a property here that you only have to report it if there's tax to pay. So the issue is, what's the question? If there's one of the...
Yeah, one's UK
resident. If the PR is non-resident or one of the PRs is non-resident, do you still need to report the sale?
If all your PRs are non-resident, I think you do have to report the sale, even if there is no tax to pay. And then if it's equal, it's a deadlock and it's decided by the residents of the deceased. I think that's the answer.
Okay.
But don't rely on it, folks, because that's off the top of my head.
Question here for you, Leslie. Is it definite that a will witnessed remotely before the 31st of January this year is not valid?
A lot of negatives in there, aren't there? I would say it is not certain, because if you remember back at the beginning of lockdown, there was a lot of discussion about a case called Casson and Dade. I think it was 1700 and something, where the testatrix signed the will in her carriage, and the witnesses signed. I can't remember. The witnesses watched the testatrix sign in her carriage. They were in the solicitor's office, and then they came out. There was a lot of discussion about lines of sight. And there were quite a lot of people who were arguing quite vociferously that on the basis of Casson and Dade, if a line of sight through a window, in fact 2 windows, is good enough, then why isn't witnessing via a remote link good enough? Now, my view at that point was, well, you can have that argument if you want to, but for goodness sake, let's not be heroic. So if there is any way of getting your will executed conventionally, that's clearly the right thing to do. But there were people who, as I said, argued that there was no reason why a court wouldn't decide that remote witnessing was acceptable. All the professional bodies said work on the basis that remote witnessing is not acceptable. So my view of the statutory instrument is that it has simply said for certain, remote witnessing is okay within these certain dates. If you had a remotely witnessed will before that date, I think the answer is we are not certain, and only the court would be able to decide. Where would I put my money? I have no idea. Let's just hope that none of us get any of those.
I think actually the Wills Act says it's the testator has got to sign in the presence of the witnesses, don't they, actually?
Well, it's both ways round, isn't it? The
Yeah.
testator has to sign in the presence of the witnesses.
They have to
The
sign.
witnesses afterwards have to sign in the testator's presence.
I think
So
it's arguable that if witnesses are in one room watching what's going on with the testator in another room on a video link, they're not actually in the presence, are they?
Depends what you mean by presence. If a witness is okay, and there's one really ancient case where they were in separate rooms without a line of sight. Unsurprisingly, the answer was that the will wasn't properly witnessed. Implication, had there been a line of sight, even though they were in separate rooms, it would have been okay. I mean, personally, I would not go to the expense of trying to prove a will which had been remotely witnessed before, what is it, January the 31st or 22nd? I can't remember which now, but whatever the relevant date is, it just seems too risky to me, but you could have a go.
Okay, thank you very much. Another question here. I'll put this to you, John. Some years ago, I dealt with the estate of a man who died without partner, but leaving 2 children. There was no suggestion there was any other children, but I've just received a letter from a person claiming to be the child of this man. What should I do?
This is sort of a nightmare scenario, actually. But there we are. It does sometimes happen that children sometimes creep out of the woodwork that no one really knows about, and things like that, actually. Well, I mean, the child is this child who's suddenly come forward is, of course, entitled to share in this man's estate. And that remains the case, that he's still entitled. But he can certainly go after the other 2 children to recover whatever is due to him, in effect, actually. And I think if they've done the Section 27, it doesn't say whether this person died intestate or not, does it, actually, the question?
No, the question doesn't say, actually, no.
Presumably, if it was intestate, then the other 2 children would have taken out the grant of letters of administration, actually. And if they've done their Section 27 Trustee Act advertisements, well, I'm not totally certain it's going to protect them, because they only protect personal representatives from claims for which, well, they're totally unaware. And it doesn't stop someone else going after the beneficiaries. It's not a bar.
It doesn't stop them going against the beneficiaries. And in your example, the beneficiaries are also the personal representatives. So the adverts actually arguably perform very little useful function, apart from perhaps flushing out some claims, which is practically useful. Obviously, if you had separate personal representatives from the people who were entitled to the estate, you would always want to do your Section 27 adverts to protect yourself against exactly this kind of nightmare scenario.
Yes, if this person had left a will appointing partners in the firm's executive, something like that, you do Section 27 adverts, which would protect the partners, but it wouldn't protect the other 2 children from the claims from this child who come to light. And obviously,
I think another problem that we've come across in cases sort of similar to this, but possibly before they've been distributed, is if the deceased has had children out of wedlock, it might be that there is a child, but on the birth certificate of the child, the father isn't named, which then makes it quite difficult to prove that person's particular claim. You know, there may be no dispute that they are the child of the deceased, but you know, you're then in the realms of DNA, and that can be very, very difficult depending on what sort of sums involved, really.
Yes, I mean, there is the issue about whether this person really is the child of the deceased, and well, I think as long as you've got a hair of the deceased, that DNA can be extracted from it, but it might be difficult to get it at that stage.
Thank you. Here's a question for you, Leslie. Presumably, where an asset is left specifically to a charity, any sale is automatically on behalf of the charity?
Yes, this is getting at the bit of the talk that I did about capital gains tax and charities. There is an exemption from capital gains tax where the proceeds are going to be applied for charitable purposes. And one of the problems that people often run into is if they're selling an asset which is part of the residue and the residuary beneficiary is a charity, you often think, oh, well, I'm selling this. It's not been specifically given. The charity is the residuary beneficiary, so they're entitled to the proceeds. I will just sell it and automatically get the charity exemption. And that doesn't work because the revenue will simply say, you have sold this asset as part of the administration process. You didn't sell it on behalf of the residuary beneficiary. So in that case, you would always want a piece of paper evidencing the fact that you appropriated the asset to the residuary beneficiary and then sold on their behalf. Now, where it's an asset which has been specifically left to a charity, the only issue is whether or not the personal representatives need that asset for the purposes of the administration. As soon as they are satisfied that they don't need it for the purposes of the administration, they would normally assent it to the charity. The charity would very likely say, we don't actually want the asset, we want you to sell on our behalf, and you can then sell on their behalf. The only issue is, whether or not it is clear that you didn't need the asset for the purposes of the administration. So you might choose to have something in writing to show that, this asset was sold on behalf of the charity. In fact, I think I nearly always would want to have something in writing, just, to head off any possible argument.
Yes, I agree, actually. I think the revenue will accept, I think their manuals do say this, that if executors, administrators completed the administration of the estate, they have become their trustees, in effect.
Yeah.
Beneficiaries. But
they say exactly that.
It's far better to have a bit of paper appropriating it in favour of the charity. Then there can't be any argument about it at all or anything like that.
But if the charity is actually entitled to the asset because it was a specific gift, then what you'd really want is an assent, isn't it? Because they are entitled to that asset unless the PRs need it for the administration.
Yeah.
Thank you. There's a question for you, John. Should you do a bankruptcy search against the beneficiaries before distributing assets to them?
I think the answer to this is yes, on the whole, actually. Certainly the major beneficiaries. But I think when someone first goes and dies, certainly if you're a residuary beneficiary, all you've got initially is just a right to have the assets administered. It shows in action. New piece of property coming into existence at the moment of death. Now, if someone is made bankrupt during the administration period, that shows in action vests in the trustee in bankruptcy and remains vested even if the beneficiary gets their discharge from bankruptcy. So I think it is a good idea to do a bankruptcy search against certainly the major beneficiaries before you start distributing anything to them, just in case they have gone bankrupt during the administration period. And also I think there are perhaps some arguments for saying that you should do a bankruptcy search against certainly the major beneficiaries when someone first goes and dies, actually. Because when someone's made bankrupt, there's an entry put on at the Large Land Charges Registry, but that will disappear after 5 years. Now, if someone is bankrupt when someone goes and dies, leaving them perhaps the residuary estate or part of the residuary estate, it is after acquired property that the trustee in bankruptcy does have rights to, actually. And the danger here is if you've got a beneficiary, shall we say, who's 4 years, 11 months into the bankruptcy, when someone goes and dies, leaving them the residuary estate, then, well, it takes you 2-3 months to sort out the estate, and you do your bankruptcy search, you won't know that beneficiary is bankrupt when the deceased first went and died, because the entry at the Land Charges Registry will automatically disappear after 5 years. So I think there are arguments for saying, certainly before you distribute against the major beneficiaries, and also before, when someone first goes and dies, again, just against the major beneficiaries. And I say major, I mean, I'm not totally certain the trustee in bankruptcy is going to be that worried about legacies of £100 or something like that, or £500. I don't know, or even £1,000 possibly. But certainly, I think anything above that, yes, you do perhaps need to do these bankruptcy searches. And of course, the other issue, of course, is beneficiaries who are abroad. Because I have no idea about foreign bankruptcy laws or anything like that at all.
You can, we help do them. You can do them in the jurisdictions where that is actually allowed. So we can do them. The costs vary and the timings vary, and some of them are only valid for the very day that the bankruptcy search is made. So we sometimes get inquiries to maybe do a bankruptcy search in New Zealand or America or Australia, which we can do, but we have to say to the client, on the day that we've done that search, that's the day that really you should then be looking to distribute, because anything, technically they could then become bankrupt the following day and we wouldn't know. So, in fact, interesting, John, I had a client recently, we did some work for them, we found some beneficiaries, and before they distributed, they were in the UK, they did a bankruptcy search on all of them, and one of them was found to be bankrupt. And the firm contacted me to say, we don't know who the trustee in bankruptcy is. It wasn't a huge sum of money, it was a few £1,000s. They didn't really know what to do, and actually I didn't really know what to advise them. Is there anything that I could go back to them and advise them? I wasn't quite sure what to do. They didn't know who the trustee in bankruptcy was. They're going to go and try and write to the beneficiary and ask them to provide that information. But if the beneficiary didn't do that, where do they?
Well, I think the official register of bankrupts, actually, which presumably would tell you who the trustee in bankruptcy is.
Right. So we had a question in there about international beneficiaries are abroad. So I'm thinking we've kind of covered that there. So I won't come back to that. A question for you, Leslie. Is it always necessary to appropriate an asset to a residuary charity before sale?
Oh, I sort of answered that one in the preliminary to my second one, but I'll just repeat it very quickly. Yes, if you are going to sell an asset which is going to trigger a charge to capital gains tax, and it's comprised in the residue, and you've got a residuary beneficiary as your charity, yes, you must appropriate it to the charity so you can sell on their behalf, and the gain is then exempt. If, on the other hand, you're going to sell an asset which has not gone up since the date of death, then there's no need to appropriate it to the charity because there is no gain. So it isn't necessary to do so in that case. But normally, if any chance of a capital gains tax liability arising, appropriate it to the charity first. Okay,
thank you. And for you, John, how long after death should you wait before you transfer assets to beneficiaries?
Yes, this is always a difficult one, isn't it, actually?
Give me my money now.
Yes, I know, because some want to be paid the day before death, if not the day of death, actually. But there we are. But yes, I mean, the answer, I think, really is you've got to make sure that you satisfy all the debts and liabilities and the tax liabilities of the deceased and the estate. But even then, I mean, claims can creep out of the woodwork, can't they? You do your Section 27 adverts, but whilst that will protect the personal representatives, the executors, administrators, it doesn't stop them going against the beneficiaries, actually. So I think with quite a lot of estates, you can be pretty certain you know all the debts and liabilities, actually. You know, particularly if you've got someone who's been in a care home for many, many years, perhaps no children, no spouse, partner, or anything like that. I think you'd be pretty certain you know all about the debts and liabilities, actually. But having said that, many years ago, I did have an estate like that and distributed it, and we suddenly got a letter from a pension fund claiming there'd been this huge overpayment of pension or something.
Oh, that is particularly common, actually.
Yes, yeah.
You have to be really careful about that one.
Yeah. But I don't know what happened to it. I think we managed to get the money from the beneficiaries actually at the end of the day, but there we are. But certainly, yes, there's obviously a risk, isn't there? But you can't just sort of hang on to the assets indefinitely because the beneficiaries are just not going to be very happy about it. You've always got to say.
There's also the issue of possible claims under the 1975 Act, because something people often say to me is, well, the PRs are protected if they wait for 6 months after the date of the grant and then distribute. If somebody then gets leave to apply out of time, the personal representatives are protected, although the court could grab back the assets from the beneficiaries. So you must wait 6 months from the date of the grant if there's any possibility of a 1975 Act claim. And then some people say, oh, but you have 4 months from the issue of the grant, from the issue of the claim, 4 months in which you can serve it. So actually, your personal representative isn't fully protected until 10 months from the date of the grant, because your claimant could issue right at the end of the 6-month period and then really hang about and not serve it on you for another 4 months. And I go, yeah, well, that's true.
I was aware of that, actually, that there are arguments of saying you ought to wait 10 months in effect.
Well, there's a question actually come in that said just now, should executors, especially professional, always wait 10 months from the grant to protect against 1975 Act claims?
Yes, if you're being ultra cautious. What I do, though, really struggle to imagine this claimant who waits until the very last minute of the 6 months to get the claim out. Well, that's not so surprising because it is quite a lot of paperwork. But okay, so they manage to get their claim out, and then they sit around for 4 months before they serve notice, and you have no idea that there is this person knocking around who might be bringing a 1975 Act claim. So if you want to be very cautious, yes, wait your 10 months, but I think it's going to be relatively rare that you won't have an inkling that there's a 75 Act claim.
And also, I think that I haven't done contentious probate, but I think there are protocols that you are supposed to tell the personal representatives on, actually, aren't you?
Yes.
To sort of begin the proceeding.
Well, there's the ACTAPS protocol, which says, the first thing that you do is tell the people and try and arrange a meeting and achieve a settlement.
Yes. Yeah. So chances are you will, actually. But yes, these claims under the 75 Act, again, they can creep out of the woodwork, actually, because I remember having an estate where this man had been in a care home for donkey's years, no spouse, no children, Alzheimer's disease, and sort of sorted out his estate. But although I didn't take it, a secretary said she'd taken a phone call from a lady who claimed to have lived with this man. Well, cohabitees can claim under the 75 Act. And it did rather raise the question in my mind that if someone does finish up in a care home and you have been living with them, can you still continue to cohabit with them? I don't know. I can see it.
Ooh, if they were in hospital, there's a few cases, I'm just going to take this seriously for a moment. There are a few cases that say it depends whether or not the relationship is continuing.
Yes.
Because the cohabiting relationship can continue even though you are separated by circumstance. Yes. But on the other hand, if he's been in the care home for many years and there's been no sign of this lady,
I agree with you completely.
The relationship was not continuing.
I agree. If she's visited regularly, then I think he still can cohabit. But just ignore him. No.
Okay, just one last quick question for Leslie. Does video execution have to be recorded?
Oh, no, it doesn't have to be recorded. The guidance that came out in July recommended, that's the government guidance, recommended that it be recorded. And I think the Law Society practice note suggests that as a precaution you record it, but no need. If you do record it, then you've got this problem, who is going to be responsible for storing the recording? And if you're using Zoom, which a lot of people do, you can either record on the laptop, on your device, or you can record to the cloud. But if you record to the cloud, you have to download it within 30 days or it disappears. So if you were going to record, you would have to have a discussion with the client about who was going to set up the meeting and who was going to record it and where was it going to be stored. And one of the things that the Law Society's practice note says is that if you are going to be responsible for the recording and the storing, do you want to say in advance that you are going to make an extra charge for that? Because obviously it's an extra piece of work to be responsible for.
Thank you, Leslie. Well, unfortunately, that is all we have time for today. Thank you for attending Law 2020 online Wills and Probate Shape the Debate, hosted by Estate Research, and thank you both to our expert speakers, Professor Leslie King and John Thurston. I'd like to wish everyone a Merry Christmas and hopefully a more normal 2021 for everybody. Don't forget to join the Solicitors Group Law 2020 online community on LinkedIn to continue the debate after the live session and to be included in exclusive offers for future events. As I mentioned today at the beginning, a recording of today's live Q&A will be sent out by email within the next couple of days. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. And there is still time to buy the complete event, including a recording of this live session if you haven't already. To book, just go to www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. The exhibition is open for anyone to visit, and if you have booked the entire event, you can claim your free 1-hour CPD webinar from the 2020 Distance Learning Catalogue, which is worth £35 plus VAT. You can also visit our exhibitor profile for more information on our firm Estate Research. Feedback forms for the event will be sent out when the event closes, and by completing this you'll receive your CPD certificate. So I'd like to thank you all again, and again thank Professor Leslie King and John Thurston, and have a great day everybody. Thank you very much. Thanks.
Thank you, Alex. Thank you, John.